petition, a fresh filing.
I have fixed certain cases for today. I will not be hearing any other matter.
Out of list, I was praying, there is an urgency. The respondents are the lessee plot holders of Bokaro State.
Yesterday, a few matters were mentioned and listed. I was told that all the defects have been removed, but still the defects were not removed. If you don't have the case number, don't.
I have the case number.
What is the urgency?
The urgency is that the respondents are lessee plot holders of Bokaro Steel, and the steel management managers are restraining them from carrying out the trade, asking them to pay hefty amount and take their permission, or otherwise they'll disconnect.
It's a matter of regular
They'll
bench.
disconnect. The threat is they'll disconnect the electricity and water supply.
Without notice.
But they have given us
There
a
is no
notice.
such step. There is no instructions to apply. There is no
There is no
such step.
such
So
There is they have converted to change the user of the property. There is a
Let this be
notice.
recorded.
Why should it be recorded? Let us give you notice.
This
If my
state
lawyer
does
friend
not
is-
behave. We are from Jharkhand. We know
They
how
can't
each
mention in the
company.
chat.
All summers, this is the
Mr.
standard
Sinha, you
practice.
just take care.
Well, we will tell them there is a notice that you pay an amount because you change the user. That's about
There
it.
is a public notice.
There is a professional urgency.
Yes.
Manoj, there is a public notice in newspaper where they are saying that you will disconnect electricity and water. What more, Manoj, I can place?
I'll tell.
If I was only saying, Manoj, it may be listed if I am not guessing if my, not today, Manoj, anytime tomorrow, next week, Manoj, whatever,
We
before
can-
summer vacations, Manoj.
It's a professional call. Tomorrow. You just seek instruction. I'll just record your submission tomorrow. I will record your submission tomorrow, call for a counter affidavit, and that's it.
Tomorrow I think that regular bench will be open.
That's very good.
Great.
All the defects have been removed. Urgency.
No, unless you have the case number, we will.
I have the case number, right? 1808 up to 2015.
Case number.
Yes.
Yes.
Urgency that the petitioner has been ordered to be evicted by the rent controller. And the next date has been fixed in the rent controller is due for the 7th of May. Any date before
7th on May for what?
The other
You
side.
go and file appeal?
We appeal. Rent controller decided in my favor, my lord.
Okay. So you
But
should be
we
happy.
lost in appeal and revision. That's then great, my lord.
So why are you just mentioning about it?
Any date not before 7th, Lord. Before 7th, Lord. I'm not passing it today or tomorrow, Lord. Any date before 7th.
What is the main point?
When point that the petitioner has got a registered deed of the land in question, Lord. He is the rightful owner, and he has been directed to be evicted from the land.
Go and file a suit.
Suit is pending, Lord. Suit is also pending, Lord. That point has been raised before the in appeal and revision also.
Difficult to get a relief because the rent controller has got the jurisdiction. to
Rent control
ratify
has
CIT.
rent control decided in my favor, my lord. In appeal, it has been overturned, Lord, by the
Certainly.
appellate court.
Appellate court has the jurisdiction to
No,
turn
no,
up.
that is true, my lord. Any date not was said before.
Who's for the other side?
Notice. Manish Kumar, I will inform her, and other than notice will go to the private respondent.
Notice भी इतना आसानी से नहीं होगा कल के लिए रखें. अब the regular bench is available.
I will try and like.
Lordship and eviction matter, Your Lordship.
Rent controller.
No, land acquisition, Your Lordship. The issue is that respondent number 1, which is
It is of
CRPF.
this bench.
No, Your Lordship.
Why did there is no
Only
urgency?
urgency is, Your Lordship, that they have bob wired one of my gate.
Mr.
and now-
आकाश एक ऑफिस के 4 लोग मेंशन स्लिप लेके खड़े नहीं हो सकते.
Your Lordship, it is.
हाँ?
I
I know. यहाँ पे
But-
कौन-कौन लोग किस-किस ऑफिस के हैं? एक
Lordship.
ऑफिस के 4 लोग मेंशन स्लिप लेके नहीं खड़े.
But this is, Your Lordship, only the urgency, if I may, Your Lordship. Urgency is that they have bob wired one of my gate, and now
You have the
every-
case number?
Yes, Your Lordship.
सब tomorrow. आपको क्या?
This case was mentioned yesterday, it's fixed today in the roster of
We'll
our
take. Who's for the other side?
Mr. Ashok Kumar Yadav. I informed
Inform him, ask him to be here at 2:15. We'll take up the matter first at 2:15 and then we will proceed with the rest. That's all?
From daily list for Pandas Soul Item 1, WPC
Mr.
187.
Niazi has joined online. Yes, why didn't you mention? I was informed that he is joining online.
My serial number 5 में है
Are you there?
only request माले 250
2:15. Just. Your matter has been posted today. The order was also circulated to you. A copy of the order was forwarded. The notice is not yet complete, it seems. One of the respondent, although we had dictated in the order that he has been served, but when we checked the office note, we found that he has not been served. Respondent number 27 perhaps.
Lordship, may I make a submission?
Yes?
If Lordship is referring to my matter and item
Yes,
5.
yes, I am referring to your matter.
Yes, Lordship, that is an inadvertent error in that, Lordship, because Lordship has recorded in the order that respondent number 57 has not been served.
That's right.
But Lordship could see the supplementary affidavit filed by the other side,
Okay.
where the service is complete. The last page of that supplementary affidavit.
Is that so?
Yes.
We will see the record. Can you join at 2:15? We will see the record
No,
and
no,
modify.
no, I'll Lordship may please. I'll Lordship may please.
Okay. No problem.
From Dailies for Final Disclosure, Item 1, WPC 1873/118 along with Item 2.
May I please, Your Ladyship? My apologies, Your Ladyship, I was a little delayed.
Late season, my lords.
Yes. How are
As
you?
Mr. Krishnan and we are on the same side. I am taking a lordship leave to give a quick 5-minute summary. And my learned friend is fully ready with it, brothers, he will continue.
That's
I
right.
have a partner, so which I will take a lordship leave, but I will again try to join when I can.
Okay.
Only 3 or 4, 5 minutes in the beginning, which is this, brothers. Your lordship has several meaty and major issues of law to be decided. Before I come to a suggestion, brothers, the meaty and substantial issues of law to be decided include first and foremost something which your lordship's jurisprudence has sanctified from the 1950s. In a very colourful phrase, hearer must decide, decider must hear. That is from the old days, each better. That is from the old judgment in the 50s right up to date in several judgments. And your lordships have said from Gullapalli and Otto after that you cannot have X hearing, Y looking at the minutes and Z deciding. Now this is precisely what has happened here without going into details. The show cause is issued. It is adjudicated after hearing by one Mr. Gyanesh Bharti. Mr. Bharti is transferred. The minutes made by Mr. Bharti are passed on to some Mr. X. And finally, on the basis of those minutes and other notings in the file, the decision is made by Mr. Y. Mr. Y's name is Paleria. So this is on the shorter issue, and natural justice is not a mantra only. Your lordship has said now, it is fundamental in terms of voidness. Natural justice violation has been elevated to be a part of Article 14, which it was not earlier in the common law. And this, will by itself be sufficient to void the decision. This is a shorter and a simpler point which will elaborate, as we go into the details. The second issue is, the EC revocation issue on the merits, which your lordship need not go into if the natural justice point succeeds. Now on the EC, the whole issue is that the expansion or the movement of the plant is in a small micro area which was not the studied area under the environment impact assessment. That's the whole issue. First and foremost, the area is so minor as to be inconsequential and purely really a Shylock pound of flesh kind of argument. Second and more important, the show cause is issued on this very basis on 6th of June 2012. Your lordship is now 13 years down the line. Nothing happens for 6 years. Mainly because it is inconsequential, it's a technical overlap. In 2018, a second show cause is issued. So, this 6 years led us all to believe, from 12 to 18, that this does not deserve any action, there is no illegality. Moreover, there is a judicial order of November 2012, inter partes, which gives a mandamus to decide my application for consent to operate in my favor. As I told you, I will give you a synoptic account very quickly before coming to the solution. This order is inter partes on a 2012 judicial order. It is therefore issue estoppel between us. That direction to MOEF, had it been decided, this matter would have been unnecessary. That is admittedly never decided. And therefore that issue becomes issue estoppel. It's the same MOEF, the same land, the same proponent as me. Then, Malas, the argument is that you have expanded into a non-studied area which is forest. The forest point is belied by the fact that, Malas, a mere notification under the Indian Forest Act of 1910 or 12, the older act, not the current act, has been held by your lordships in several judgments from the 1960s that merely a notification will not make an area forest. What is worse is that in the present case, these very notifications on which the department now relies has been held to be non-est in a civil title suit decree adjudicated by a court and not challenged, not set aside. This is the third head, or rather, what is the fourth head? I'm sorry, the third head. Now, what is the biggest current problem is the fourth head, which is that the FC conditions, now what is, it's at the stage of forest clearance, FC. Phase 1 was given, phase 2 is imminent, and then there is an argument that phase 1 is lapsed because phase 2 has not happened and time is elapsed. Now, what is the principal problem here is something bizarre, I say with great respect. The condition is put that you must take 6 times of the compensatory afforestation land. 6 times. Whereas A, there is no sanction for 6 times in the penalty contemplated even in the handbook. B, a penal power like this cannot be applied without specific statutory sanction. C, ultimately, this is been held by lordships innumerable times that penal powers must be specifically provided for. You can't just pluck out 6 times. Whereas amazingly, in the minutes of 23/9/2024, said earlier, 23/9/2024, the FAC itself acknowledges that there is no basis to ask for 6 times. That is last year. Well, as the suggestion I would leave with my lords, although lordship may hear it, lordship wants to, but there is a way out. One is a narrower point of natural justice, but the other way out is with us. In any case, overriding everything, a new application for FC has been made on 12th of March 2025, which is on record. The old FC was revoked on 5/6/2023 on grounds of time passage and non-compliance. Even that old EC reconsideration is pending, but forget the old EC, there is a new EC application on 12/3/25. In the event, my IA, which asks for consideration of my pending EC application, is expedited, the matter will not require any adjudication. And there is no reason why your lordship should be asked by the respondents to adjudicate something without the same respondent deciding my application for FC. So, actually 2 things will happen. Your lordship will be asked to enter into a futile exercise, and B, your lordship will be really, in a sense, by passing a judgment precluding the possibility of my FC application pending from 1 month or now almost 1.5 months. They will say we will not decide it because the lordship has passed a judgment. So, in a summary, as I ask and request my learned colleague, Mr. Krishnan, this is the lie of the land. Your lordship is entitled to say that with sizer of the matter, a time-bound direction is given. It is ultimately their discretion. They can allow or dismiss. Or your lordship will also consider your lordship must decide then the short, narrow issue of natural justice. I
will take care of everything. 2 things I am making it very clear. I will decide the case on the basis of admitted facts on record, admitted from your side as well. So there is no question of any natural justice. Firstly. Secondly, if there is any particular application pending from your end, I can just indicate that this judgment will have no bearing on that. Because that will be a fresh look altogether. We cannot keep this matter pending anymore. I have made it very, very clear, and I will decide whatever it is, whatever is available on record, I will decide.
Well, nobody is asking a lordship to adjourn it. I am only giving a lordship a context.
So these two things we will take care of. So far as natural justice is concerned, I will decide only on the basis of admitted facts. So there is no question of any natural justice. We have had
Can
enough
I-
of natural justice. Now the second part is that so far as your pending application is concerned, I can finally indicate that this will have no bearing. Now this matter cannot go on for indefinite period of time.
Can I just take 30 seconds to respond? The matter will take
Yes.
over. One, Malas, we are not seeking any adjournment. Two, we said this to give your lordships all the grounds.
That's right.
Three, the natural justice point with greatest respect, Malas, is in fact a preliminary threshold point. Because if the show cause is adjudicated and the impugned order follows from a from a hearer decider vitiating factor, then the impugned order goes on that ground. So it's not something, Malas, which can be superseded or got over by so-called admitted facts. That's my humble submission. Suppose an order which is impugned in the writ court violates a principle which is part of Article 14. Then, Malas, seeing other facts dehouse that order on the basis of so-called admitted facts will not cure that. Secondly, Malas,
I
about
feel
your lordship,
is
about
the core issue here is that there is an environmental clearance given for establishment of a unit at a particular point, and ultimately it has been found that it was shifted. Whatever be the shift, we'll take care of that, and that was the reason for issuance of shifts. The point is when the industry is not established on that particular point, then everything starts afresh completely. You
No, but
cannot
there is
say
one
that
problem
it is
there.
within.
One problem there. Your lordship is not hearing this writ as an original proceeding. My lord is hearing this writ as a challenge to Malas 20th September 18
I
and
will-
EC
I
an
will-
order revoking the EC.
I will confine myself to the prayers made and the records of this case.
Ultimately, well, that's your lordship prerogative. I'm only pointing out the order impugned is a written order of 20th September 18.
We'll take
If
care.
that order is heard by X and decided by Y, there is a direct judgment of 5 constitutional benches, which is the point of law. Ultimately, your lordship will decide
This
whatever
law
has
is
to do.
absolutely basic.
Well,
The person who hears it has to decide it.
yes.
So this is absolutely basic. You don't need to cite judgment for that.
On that order, Malas, which would, according to me, the consequence would be that the order would go up, subject to whatever my lord decides.
We'll
Now,
see.
secondly, on your lordship saying that this will not affect the pending application, there may be a second problem there as well, which is that whatever lordship opines here will inextricably be intertwined with the
We
elements which
cannot
decide the FC.
ignore the
Which decide the
fact.
FC.
We cannot ignore the fact that a unit is running without proper clearance. I will not shut my eyes to that. As on now, as on date, there is no proper clearance in your favor. So we cannot ignore our eyes to that.
But equally, well, there is no stoppage order, Malas. There is no stoppage order.
No,
Otherwise,
need
the
not
government
be
would
no.
have made
There
it
is already
serious
an
stoppage
order. Central
order.
government has already asked the state government to take steps, but state government is also sleeping. So why should I
No, but-
keep the matter pending? If the central government and the
No, no.
state government do not want to act, that is
about
completely their prerogative. I will not ask them to
nothing,
act.
Malas. About district, we are saying that. That should be decided.
That's
Obliged. Obliged.
Start.
Your ladyship,
Which record do you want me to take first?
4850.
481.
We've given a compilation.
We have got compilation. The entire record has been bounded and given it to me, but we don't have any list of dates as such. That I do not have.
We'll get a printout, your ladyship.
No.
In the meantime, may I begin?
Yes, sure.
Your ladyship, could I request only this? If this camera could be shifted
Yes,
a
Mr.
little to the left, so that I could observe your
That's
ladyship.
Gestures also communicate a lot. They communicate more than words.
I'm
Correct.
grateful to your ladyship. Your ladyship, I'm going to proceed on the basis with your ladyship's permission that I still have to place the arguments on each point so that your ladyship gets a complete picture.
Do you have you formulated your points?
Yes.
Please give me that.
No, not in writing.
All right.
So may I just indicate the broad heads?
Sort of. You take down all the points that is.
So the first point, of course, is natural justice. on the ground that he who hears must decide. The second and even more important point is that on the location issue, there is an order of the central government issued with the approval of the competent authority saying that the location issue does not matter because it is minor. The whole study area, had already been looked into, and this is based on the report of a central government entity which is renowned in the field of environment, that is NEERI. This was given during the time when the plant was being constructed. And it cannot be gone back on 6 years later after the plant has been completed.
Just one query. Where is this report in the report? Page number?
I'll give that to your ladyship. When I take your ladyship step by step, I'll tell your ladyship.
You just give the contours.
Yes. Then the third point, your ladyship, is the decision on the point of the forest is based on a 1958 notification under the proviso to section 29(3) of the Indian Forest Act. There are judgments of the Supreme Court, the High Court, of this Honourable Court, learned division benches, which have all pointed out that that notification never came to fruition, therefore it cannot be treated as forest.
It never came into force?
Your ladyship is aware that just like under the Land Acquisition Act, under the Forest Act, there are procedures. 29(3) contains a specific procedure. Now that procedure never culminated into a declaration of a notified forest. And this position has been taken by the Supreme Court as well as this Honourable Court. In fact, in this very case, the Supreme Court has granted stay orders based on this.
So when you say that there is no such notification,
No,
and
the
no, there is
preliminary
a
notification
but
came.
final notification is not there.
Yes.
I'm sure that it is based on the pleadings because this is absolutely a factual aspect, whether there has been any final notification or not. And then you have to show me where have you taken that plea before this.
We'll 100% show your ladyship. I'm afraid that over a long period of time, since 2018 till 2025, we had forgotten on this side of the bar because we were in the process of trying to get time to bring ourselves into compliance with what the central government was telling us. We have forgotten how the case originally started and what were the points that we made. So I'm only submitting to your ladyship with great respect that if your ladyship would hear us on each issue, your ladyship will find that in fact there is no substance in the order of the central government, which has been passed, I believe, as a knee-jerk reaction to your ladyship's direction that the show cause notice of 2012 must be decided. And I think they assumed that this Honourable Court was therefore of the view that there was a serious problem in our case and went ahead and decided it.
Our concern was that when there is a show cause,
Yes.
it has to be taken to a logical end.
Your Lord Ladyship is absolutely right.
We are not bothered, let them drop it. We don't bother about it.
But the problem
But
is
once it triggers, it cannot be kept open.
your ladyship is absolutely
And
right.
the Pollution Control Board was not deciding the matter because of the reason that the show cause was pending.
Your ladyship is absolutely right. From your ladyship's perspective and my perspective, on this side of the bar, we are fully in agreement. If a show cause notice is issued, it has to be decided. But I am trying to tell your ladyship that when this court speaks, sometimes the government attaches a significance to those words which your ladyship never intended, which this court never intended. And it appears that it is on this basis that they had pre-decided what was to be done and went ahead and followed through without taking into account our submissions on the law and on the facts. So, Your Ladyship, this is the third point. Then, Your Ladyship, on the merits of the revocation order, there is a fourth point. And this I am submitting is absolutely without justification. The fourth point the third point that they decided in the show cause is that there are non-compliances with the EC. Now, I am submitting that this was never ordered by Your Ladyship, by this Honourable Court. It could not have been clubbed with the show cause notice to revoke the EC. But there is a more fundamental point, which is that the Supreme Court has held and the Delhi High Court has held in more than one case that where a non-compliance is remediable, you do not cancel the EC. The third and most important point, in fact, immediately after this particular notice was given to us by the CTO, by the JSPCB themselves said that we are in compliance. And Your Ladyship may recall that in the years that followed, Your Ladyship allowed us to run only on the condition that JSPCB will ensure that we are in full compliance with all conditions of the consent to operate as well as the EC. And they have been consistently monitoring that. So this is not a case which unfortunately may be the impression that has been perpetuated, where we are running in violation and under court orders we are continuing to operate. If Your Ladyship were to see the record, Your Ladyship would be satisfied, I think, that they were remedied. After that, the JSPCB has been monitoring the whole issue. So, Your Ladyship, I am hoping that I will be able to show Your Ladyship, contrary to the impression that has been created by the long pendency, during which we have requested Your Ladyship to allow us to run subject to getting these clearances. If I may be able to show Your Ladyship, and I'm hoping that Your Ladyship would allow Your Ladyship to be persuaded.
Is that your discussion?
No, I'm saying to be persuaded. That is, I'm hoping that
I never close my mind.
that is my endeavour to persuade Your Ladyship on these aspects. And Your Ladyship, I just wanted to mention that therefore the belief that from 2018 to 2025 we have been running continuously without any justification in terms of compliance with conditions is absolutely not a correct one. So if I may, with this introduction, Your Ladyship, start with the point about violation of natural justice. And Your Ladyship, I would respectfully submit that if one goes by the decided judgments, then an order which has been passed in complete violation of natural justice is held by the Supreme Court. I'll show Your Ladyship the judgments. Then the order becomes void. And in a matter of this nature, Your Ladyship, I would respectfully submit, ought not to decide the issues in the show cause notice when the original authority is the expert body that is competent to decide. That is my respectful
Let us
submission.
see what are the prayers and what all are the improved orders.
Yes,
I
yes.
will be confining myself only to the prayers and the improved orders.
Correct.
And I will not travel beyond that.
Yes, we are on 4850 for the time being
485.
because it's a challenge to the revocation of the EC. The subsequent order is passed based on this revocation. Or the subsequent order of JSPC, which we have challenged in a second, it is based only on this revocation.
We'll see that later.
This therefore is the genesis. If Your Ladyship would kindly come.
Let us see the cause of action of filing of this case and what was the initial prayer made.
Yes, please see at page 65 of CC1.
let's first quickly have a look at the relief and then we'll come.
Yes, 65. Page 65 is the relief in the writ petition.
Okay, 60. We normally put it in first para.
Oh, I
But
see.
it is repeated in the prayer.
Yes, I forgot your ladyship's, the court's procedure.
Yes.
An appropriate writ, order or direction for quashing of order contained in letter dated 29/2018, whereby and whereunder it is communicated to the petitioner that the competent authority has decided to revoke the environment clearance, which was according to the petitioner, vide letter number dash dated 21/2/2008 with immediate effect in accordance with section 5 of the Environment Protection Act, with a further direction to the petitioner to apply for environmental clearance afresh after clearing all the issues as per the rule, and or any other appropriate writs, orders or directions as may be deemed fit and proper for doing constable justice to the petition. So
Let's
you
have a
really
look
should,
at this election act.
yes.
I'll find it at page number.
Your ladyship is looking for the revocation order. Yes, page 169. Yes.
Yes, I'm.
This is dated 20th September 2018. Your ladyship would see that it issues from the Government of India Ministry of Environment and Forests. It's dated the 20th September 18 and it is addressed to the head environment of Electro Steel. And the subject, and this is very important, your ladyship may kindly mark the subject. Revocation order under section 5 of the Environment Protection Act 1986 in view of violations pertaining to the environment clearance of integrated steel plant of electric steels located at Bokaro, Jharkhand. Your ladyship, in this context, I wanted to just inform your ladyship that this is the first integrated steel plant, greenfield integrated steel plant, set up in Jharkhand after the formation of the state. Before that, there were a few steel plants that are very old, set up in the state of Bihar, the undivided state of Bihar. Yes. Now please see, now this section 5 is very important to your ladyship. It is the most important or one of the most important sections in the Environment Protection Act.
Environment Protection Act. So this is one different जो भी समझ आया वैसे I am noting it also. Yes.
Please see, your ladyship, there are two powers in chapter 2. One, of course, is section 3. Subject to the provisions of this act, the central government shall have the power to take all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling and abating environment pollution. In particular, and without prejudice to the generality of the provisions of subsection 1, such measures may include measures with respect to all or any of the following matters. And then it includes coordination of actions by state governments, officers and other authorities under this Act or rules, planning and execution of a nationwide program for prevention, control and abatement of environmental pollution, laying down standards for the quality of the environment, etc. etc. Now please turn to the provision at issue, which is section 5. Power to give directions. Notwithstanding anything contained in any other law, but subject to the provisions of this Act, the central government may, in the exercise of its powers and performance of its functions under this Act, issue directions in writing to any person or officer or any authority, and such person, officer or authority shall be bound to comply with such directions. Explanation. For the avoidance of doubts, it is hereby declared that the power to issue directions under this section includes the power to direct A, the closure, prohibition or regulation of any industry, operation or process, or B, stoppage or regulation of the supply of electricity or water or any other service. So it is under this power that the central government acts in relation to any industry, as it is done in my case. In this context, I wanted to show your leadership the EI notification, which is the genesis of the process for getting an environment clearance. Your ladyship would see, I just tell your ladyship because it appears, unfortunately, that we haven't put it into a compilation.
Notification later.
This is the 14th September 2006, but it's been amended several times subsequently. 14th September. This is the environment, this is popularly known as the Environment Impact Assessment Notification.
Environment Impact Assessment Notification.
Yes.
14/6/2006.
Yes. So I'll just read. Whereas a draft notification under sub-rule 3 of Rule 5 of the Environment Protection Rules 1986 for imposing certain restrictions and prohibitions on new projects or activities, or on the expansion or modernization of existing projects or activities based on their potential environmental impacts, as indicated in the schedule to the notification, being undertaken in any part.
I don't need it. It's here.
Yes.
If you have not got it, please take it. It's in the book itself. Continue to use.
Yes. So it is under sub-rule 3 of Rule 5 of the EP Rules 1982 for imposing certain restrictions and prohibitions on new projects or activities, or on the expansion or modernization of existing projects or activities based on their potential environmental impacts as indicated in the schedule to the notification, being undertaken in any part of India unless prior environmental clearance has been in accordance with the objectives of the National Environment Policy as approved by the Union Cabinet on 18 May 2006, and the procedure specified in the notification by a central government of the state or union territory level Environment Impact Assessment Notification Authority to be constituted by the central government in consultation with the state government, the union territory administration, etc. And then your ladyship, if your ladyship sees the fulcrum on which it turns, if your ladyship turns to paragraph 2 of this notification, requirements of prior environmental clearance. Yes. The following projects or activities shall require prior environmental clearance from the concerned regulatory authority, which shall hereinafter referred to, which shall be hereinafter referred to as the central government, the Ministry of Environment and Forests, for matters falling under category A in the schedule, and at state level, the State Environment Impact Assessment Authority for matters falling under category B in the said schedule, before any construction work or preparation of land by the project management, except for securing the land is starting on the project or activity. And then it talks about all new projects in 1, expansion and modernization in 2, and any change in product mix in 3. And I don't need to take your ladyship through the rest of the notification, but it is under this notification that we got the environment clearance at issue. But the key point I want to make here is that it has been revoked, admittedly under section 5. The revocation order is passed under section 5.
your clearance by the ministry and by the state was given on which date? And
Yes.
where is that order of clearance?
Yes, let me just, it's at page 86 of the compilation. February 2008. Annexure 4 in CC1.
One thing I want to know from you, which I could not get from the record, you just turn to the previous page, just the previous page which is in Hindi.
Yes.
There is one enclosure 3 to it.
Annexure 3 your leadership is talking about?
Yes, yes.
Yes.
Enclosure 3. Annexure 3, and there is this document called Enclosure 3. Just above the bottom, 4-5 lines. What is this Enclosure 3? I think I could not get it. Certain queries were put by the. This was the concern of the local people.
Yes, yes,
Yes.
probably the concerns
So
of
the environmental clearance also has certain obligations cast on you regarding the local people.
Let me explain that, Your Ladyship.
No, I just want
Yes.
you to have the list. Just have the list of that.
Of the
Of your
objections.
compliances. No, not the objections. As per the environmental clearance, what all were you required to do for the local? I just want to out of the this may not be much related, but I just want to have a list of that. What were your obligations to the local people
Please,
by giving the clearance?
to the local people. The conditions are at page 87. Specific conditions. And there is no allegation in relation to these, is my respectful submission.
I just wanted to.
The first condition.
That is not the allegation that you have not complied with that, but I just wanted to have.
Yes, please see small Roman 1 under A. Confirmation to the land houseties for acquisition of agricultural land shall be paid as state government norms and the norms prescribed in the National Resettlement and Rehabilitation Policy 2007. Then there are various conditions related to the environment. Then, if your leadership comes down to general conditions,
Page 72, Roman 9.
yes.
7 and 9.
Comply, yes. Occupational health surveillance of the workers shall be done on a regular basis and records maintained as per the Factories Act. And 9, project proponents shall also comply with all the environmental protection measures and safeguards recommended in the EIA ENP report. Further, company must undertake socio-economic development activities in the surrounding villages like community development programs, education programs, drinking water supply, care, etc.
This is the obligation.
Yes, yes. And your leadership may recall that over the last 8 years we've done a number of additional things.
Have you opened any school?
We have skill development schools, archery schools, etc., etc.
Last 10.
Your leadership.
Regular school. Our state is starving for good schools. I just wanted to know because education is also one of the aspect in this.
We'll find out and come back to it.
I just off the record. I
Yes.
just don't
But
want to know.
I believe, if I remember correctly, your leadership, this is me personally, as council.
I remember that many off the record directions were also followed. And many things you have done.
No, so we had conducted a number of programs for
Yes.
girl children in schools,
Yes.
etc., etc.
Yes, I'm aware.
Yes.
We were on page number 86.
Yes, 86. So this is the environment clearance your leadership at issue. And thereafter, if I may now take your leadership, shall I proceed to the revocation order, your leadership?
Total project area was 1350 acres.
Yes.
Which was partly agricultural, no national park and wildlife sanctuary was located in there. No forest area, no forest land was involved.
Yes.
And this was, the clearance was in which village? In which Mauza?
It says Parbatpur.
Yes, Parvat. Okay.
Yes. Now, your ladyship, if your ladyship were to come, huh? Would your ladyship come to page 246?
Yes. Yes, personally.
246, your ladyship, is the just one moment, your ladyship. Yes. Huh? No, this is the personal. Yes.
No, we are conscious of the fact that this particular step regarding social hearing and public hearing, which is required, has been undertaken. There is no doubt on that. The clearance was given to you, and that clearance was in accordance with law. There is no doubt on that. The point is violation.
Your Lordship, I think I would like to clarify that a little bit. We have two separate issues. One issue is that the original clearance was granted based on wrong facts. The separate issue is alleged wrong facts. The second issue is non-compliance with the conditions of the EC, which I am respectfully submitting is an entirely separate issue, not covered by Section 5 of the Act. That is why I took your ladyship to Section 5. A Section 5 hearing is statutory in nature and is governed by the rules. Now, if your ladyship just sees at page 246, this is the minutes of the personal hearing held at 10:00 hours on 10/9/2018. Yes. Your ladyship sees that? Held at 10:00 hours on 10/9/18 at Indus Hall, Indra Paryavaran Bhavan, on the clarifications furnished by Electrosteels Limited in response to the show cause notice dated 6/6 and the non-compliances. Now, this is the part which I am taking objection to. This was not directed by your ladyship and has been separately done and clubbed with this hearing. Now, please see, reported in the monitoring report of the regional office of MOEF and CC at Ranchi. In pursuance to the personal hearing notice dated 31/28/2018, hearing took place. Please notice the words personal hearing notice. So this is in accordance with statutory procedure. Dated 31/8/2018, hearing took place at 10:00 hours on 10 September 2018. Shri Dhyanesh Bharati IAS, Joint Secretary, heard the matter. Shri Sandeep Sharma, Assistant Inspector General of Forest, Shri Sharat Kumar Palaria, Scientist F, Shri Sundar Ramanathan, Scientist D, Shri Rajiv Ranjan, Scientist D, Regional Office of the Ranchi, and etc. were also present during the hearing. But the hearing, yes. Now, the submission I am making is, it is heard by Shri Ganesh Bharati IAS. Your ladyship sees that? Thereafter, and the others are noticed as being present. Now, I want to take your ladyship to para 4. Para 4. Initiating the hearing, Shri Ganesh Bharati, Joint Secretary, informed the participants about the purpose of the hearing. He further informed that written submissions have been received from ESL video letter dated 7/9/2018. JSPCB video letter dated 6/9/2018. State government, State Forest Department, etc. and District Collector cum District Magistrate Bokaro, a video letter dated dash. During the hearing, ESL submitted supplementary reply documents. The response of ESL and the remaining parties concerned were heard. After hearing the parties concerned, Joint Secretary asked the officers concerned in the Ministry to examine the written submission submitted by the parties in detail. Okay, leadership sees that. Now, yes. Now I wanted to show your leadership the actual file notice. Please come straight away to page 229. Your leadership sees that. Revocation order under section 5 of the Environment Protection Act 1986 in view violations pertaining to the environment clearance of integrated steel plant located in Bokaro. Then he starts giving his views. The submission we are making is, if your ladyship comes straight away to page 242. In view of the above, Ministry may like to consider following course of action. Revoke the environment clearance accorded PD letter number dash to Electro Steels with immediate effect in accordance with section 5. Please see again section 5. Accordingly, DFA is placed below. Further, it is also proposed that the revocation order may be seen by FC division. FC is Forest Clearance Division, is one of the issues pertains to forest land. It is respectfully submitted that decision of the aforesaid matter may please be taken by 18/9/2018 so as to facilitate the filing of affidavit in the Honourable Court by 29/2018. Your ladyship would see that it is this Honourable Court's order, therefore, that is playing in the minds of the officers. But the key point I wanted to make is, please see who is signing this law. Yes, submitted for the kind perusal, consideration for the orders, please. Your ladyship sees that. And please see who signs it. It is Sundar Ramanathan, Scientist D, 11/9/2018. Now this date becomes crucial because your ladyship would note it is the very next day after the personal hearing. Now please see below that, it is not very clear to me, to us, as to whether he approved it or not, but your ladyship will see on the bottom left, just below, submitted for Director SKP, submitted for consideration and perusal, please. And then on the left hand side, JS brackets GB or CB is what it looks like. And on the right of that, immediately to the right, your ladyship sees a signature. 11/9/2018, which we believe to be that of Gyanesh Parthe, because he is the JS as of the date 11/9/2018. Now I want to show your ladyship 245. Please see, it is dated 12th September 2018. It's a transfer order by the, it goes under the signature of an Under Secretary to the Government of India, presumably in the Ministry of Environment, Forest and Climate Change, which is given on the top, in pursuance of the DOPT communication dated 10 September 2018. Please see that date, Your Ladyship. So on the date of the hearing, the decision has come down from DOPT to MOEF. Shri Gyanesh Bharti, Joint Secretary, is hereby relieved from Ministry of Environment, Forest and Climate Change with effect from afternoon of 12th September 2018 to Joint Cabinet Secretary. So, Your Ladyship will see between the personal hearing conducted on the morning of 10th and the date on which he signs, this order has already come from DOPT to the Ministry and it is formalized in this communication on the 12th. Now, I wanted to show Your Ladyship the affidavit which is at page 194, and then I will make my submission as to the crucial points that arise from the facts I have shown Your Ladyship. In fact, at 193 is para 11. And the affidavit starts at page 188 for what it is worth. Union's affidavit. That it is submitted that the petitioner is fabricating para 11. That it is submitted that the petitioner is fabricating facts and misleading this honorable court by false allegations of the answering respondent. It is settled law that a litigant who attempts to approach this honorable court with tainted hands is not entitled to any relief, interim or final. It is further submitted that the submission of the petitioner was duly considered by the answering respondent, and the submissions relevant to the key issues were also recorded in the order dated 29/2018. Now, this is their first answer. It is submitted that the personal hearing was conducted by the Joint Secretary, so they admit it is Gyanesh Bharti, after approval of Additional Secretary in accordance with prevailing guidelines. This may be seen from the noting of the file which is annexed herein as Annexure R1/2. That's the file noting I showed Your Ladyship. Moreover, as per the office order dated 39/2009, hearing of the project proponent may be conducted by advisor IA or additional secretary in charge IA division. It is further submitted that the joint secretary is equivalent in rank to the advisor and is a competent authority to conduct personal hearing. A copy of office order dated 39/2009 is annexed herein as Annexure R1/3. The office order dated 39/2009 had the approval of Honourable Minister of State for Environment and Forests. It is submitted that all the ingredients of principles of natural justice have been duly complied with while passing the order dated 29/2018, which has stated all the reasons which aided the competent authority to reach at the conclusion of revoking the environment clearance dated 21/2/2008 issued to the petitioner hearing. It is submitted that the Joint Secretary, and this is where I would respectfully draw Your Ladyship's attention to the incorrect statements that are made here. It is submitted that the Joint Secretary, and I'm using decidedly neutral language, Your Ladyship, because this hides more than it reveals. Shri Gyanesh Bharti was relieved from his official duty on 12/9/2018. Please notice the next sentence. He had heard the petitioner and recorded his observations with respect to the personal hearing conducted on 10/9/2018 at 10 a.m. before leaving his office. Your Ladyship sees this sentence. The averment that is made is Gyanesh Bharti heard and recorded his observations. Now please come back for a moment to page 242. Who has signed the observations which they have annexed as being the file noting made by him? It is Sundar Ramanathan, scientist D. All that Gyanesh Bharti appears to have done at the highest is to sign it in the middle after it is submitted for consideration and approval, please, by the director SKP. Your ladyship sees that?
Please be submitted for consideration and
Further orders, please.
yes.
So the whole file noting is on their own showing made only by Sundar Ramanathan. It is not made by Ganesh Bharti at all. It is merely signed by him. I could not even see anywhere where he writes approved. JSGB merely signs with a date underneath that. And this, in my respectful submission, is fatal to this order. Now please come back to page 194 of the counter affidavit. 193.
Maybe that the recording was done by somebody else, but at the time of hearing it is something like there is a stenographer to take whatever is.
That's the issue, your ladyship.
That can happen.
If Ganesh Bharti had dictated it
No,
to,
it's not a matter of dictation during the course of hearing how the proceedings have been recorded. Maybe that we do not know what exactly.
no, your ladyship, that's not their case. Please see what is stated at 194. Second paragraph. He had heard the petitioner and recorded his observations. His observations. Now, this is not a case of somebody who has taken dictation. This is not a case where the observations are being recorded. This is a case of file noting made by a responsible officer of the government, that is Sundar Ramanathan, Scientist D. And your ladyship may recall from the personal hearing minutes, kindly come back to the personal hearing minutes at page 246. Yes. Shri Ganesh, second line, Shri Ganesh Bharti IAS Joint Secretary heard the matter. And Shri Sandeep Sharma, Assistant Inspector General Forest Conservation Division, Shri Sharat Kumar Palaria, Scientist F, Shri Sundar Ramanathan, Scientist D, Shri Rajiv Ranjan, Scientist D, Regional Office Ranchi, and Shri Rajshekar Ratti, Scientist C, were also present during the hearing. Now please come back to 194 again. Let me read further. It is further submitted after the sentence about how he recorded his observations. It is further submitted that Ms. V. Vidyavati joined the office of the answering respondent as a joint secretary on 12/9/2018. It is pertinent to mention herein that it is a well-settled principle that the joint secretary was working in his official capacity and had duly recorded his observations on file, and his leaving the office cannot be a substantive ground for revocation of the order dated 29/2018. Since the order dated 29/2018 was issued after obtaining the prior approval of the Honourable Minister in compliance with the laws in vogue, this can be seen from the file noting, which is annexed herein as annexure R1/4. A copy of the office order dated 12/9/2018 issued in this respect are annexed herein as annexure R1/5. But my submission is this, your ladyship. At the very least, under whichever principle of law you consider it, I am submitting in the first instance that if the joint secretary heard, the joint secretary had to decide. But put that aside for a moment. At the very least, the person who heard had to record his observations, his decision. He had to apply his mind to the submissions and then decide something. So, this is a case of the emptiest of empty formalities. It is worse than Gullapalli Nageshwar Rao, which your ladyship is aware of. Now let me place Gullapalli.
as I remember, in one of the orders we have taken care of this aspect of the matter. And
Your ladyship had issued notice and stayed it on this very aspect.
that's right. So, and thereafter there has been subsequent proceedings and hearings, and I do not know what all happened thereafter.
Now, after this, nothing further has transpired with respect to the validity of the 29/2018 revocation order. But we have all lost sight of this, and it is our fault. We have never placed this again before your ladyship to show your ladyship that your ladyship's original order, when your ladyship issued notice and stay, was absolutely correct. Please see now in Gulapalli.
Which is that order by which it was taken?
Yes.
Order date?
27/9/2018. Your ladyship must forgive me. I have a small problem. I am used to having paper files, but the files here were so voluminous that we couldn't carry it with us and bring it, given the time constraints. And so I'm on my iPad. So I always need assistance on my iPad from my colleagues. Your ladyship is right. Like Gyanesh Bharati needed assistance from Sundar Ramnath.
This entire fact I remember has been reflected in this order while
Yes.
passing this.
Let me please see in para 3, admittedly, upon this counsel appearing on behalf of the petitioner has advanced extensive argument on the point of maintainability of the petition. He submits that this court may not enter into the technical aspects of the matter of environment clearance and will confine his argument on the point of gross violation of principles of natural justice and fair play while passing the order impugned in this petition. While advancing his arguments, he submits that the environment clearance was granted to the petitioner VD order dated 21/2/2008, issued by the Ministry of Environment and Forests. However, VD letter dated 6/6/2012, a show cause was issued to the petitioner by the said ministry asking the petitioner to show cause as to why the environmental clearance dated 21/2/2008. Oh, I'm sorry, your ladyship has it.
Some error?
Yes. Please see paras 7 onwards.
Anyways, much water has flown thereafter. Now, so far as this impugned order is concerned, this is impugned order dated
29/2018.
29/2018, which is a fallout of this so-called hearing. So, according to you, this must.
My respectful submission is that this is very blatant. It is not just that he who hears must decide. There is even more. The hearing was the emptiest of empty formalities because the man who heard was so busy in his process of going out, he did not even put down his thoughts on paper in a file noting. So let me first show Gulapalli, your ladyship, because everybody knows the judgment, but the facts are often, my lords, forgotten. Please see, the judgment compilation has been given to your ladyship. I hope your ladyship has the first compilation has Gulapalli as the first judgment.
That first time.
Yes, your ladyship may kindly come straight away to page 2 is where it starts, and then page 13 is where I wanted to take your ladyship. Please see on the left hand side, para 15. Section 68D. Any person affected by the scheme may within 30 days file objections thereto. 2. State government may, after considering the objections and after giving an opportunity to the objector or his representatives and the representatives of the state transport
So,
undertaking.
page number 13?
Yes, page number 13.
Para 17?
Para 15.
Para.
I'm showing your ladyship the provision to make it clear that
Page number 13 does
13.
not have para.
My
Oh, yes,
apologies.
it's here. Sorry, it's okay.
It is there in
It's here.
second half of
I
the
just missed it.
first column.
Yes,
The provision is extremely similar to Rule 4, which directs how you will hear a Section 5 objection. Any person affected by the scheme may within 30 days file objections thereto before the state government. 2. The state government may, after considering the objections and after giving an opportunity to the objector or his representatives in the representation and the representatives of the state transport undertaking to be heard in the matter they so desire, approve, modify the scheme. The scheme shall then be published in the official gazette, etc., etc. Now please turn to para 17. Yes. Therefore, please notice that it uses the word state government. Now please see on the right hand side. Para 17. The following procedure was in fact followed by the government in this case. After the scheme was prepared and published in the official gazette, the petitioners and others filed objections before the Secretary to Government Transport Department within the time prescribed. 138 objections were received and individual notices were issued by the government by registered post to all the objectors, fixing the date of the hearing for December 26, 1957. Secretary of Government Home Department in charge of transport heard the representations made by the objectors, some in person and others through their advocates, and also the representations made by the General Manager of the Road Transport Undertaking. Secretary, after hearing the objections, prepared notes and placed the entire matter with his notes before the Chief Minister, who considered the matter and passed orders rejecting the objections and approving the scheme. And the approved scheme was thereafter issued in the name of the government. Now, please see this on the last line of page 13. The Secretary, after hearing the objections, prepared notes. Now, even that has not happened in my case, Your Ladyship. Gyanesh Bharti, who conducted the hearing on their own showing in their counter affidavit, never even prepared the notes. Now, please see paras 13.
I just want to know that Mr. Gyanesh Bharti, after the hearing, did he sign the note or not? Given as per the file, is it apparent? It is.
No,
I appreciate that you say that the note was also prepared by somebody else.
Yes.
Fair enough.
Yes.
I just want to know, does the file noting reflect that after preparation of that note, Gyanesh Bharti had approved it or had signed it? Because that note whose signature is there is not clear.
It's not clear.
And the order has passed after he left.
Yes.
Order was communicated after he left.
Much after he left.
So the impugned order, that is 20th, does it reflect as to when, it is just a communication, does it reflect as to when was the order passed?
Not that I can see. I'll place that order. That is the order dated. But may I first, just so that we
Yes,
complete this, we'll
complete
complete 31 and 32 and then go there. Yes. Page 20, para 31. The second objection is that while the Act and the rules framed thereunder impose a duty on the state government to give a personal hearing, the procedure prescribed by the rules impose a duty on the Secretary to hear, the Chief Minister to decide. This divided responsibility is destructive of the concept of judicial hearing. Such procedure defeats the object of personal hearing. Personal hearing enables the authority concerned to watch the demeanor of the witnesses and clear up his doubts during the course of the arguments, and the party appearing to persuade the authority by reasoned argument to accept his point of view. If one person hears and then another decides, then personal hearing becomes an empty formality. We therefore hold that the said procedure followed in this case also offends another basic principle of judicial procedure. The learned counsel further contends that the mind of the state government was foreclosed before the hearing was given, and therefore no real inquiry was held by it as contemplated by the Act. And then, my lords, it comes the Deccan Patrika, etc. But I'll stop here. Please see para 35 now. In the result, for the reason that the state government did not make the inquiry consistent with the principles of natural justice in approving the scheme, the order approving the scheme is hereby quashed and the direction is issued to respondent 1 to forbear from taking over any of the routes in which the petitioners are engaged in transport business. So therefore, this was the effect. I now want to show another judgment in which I had appeared and unfortunately lost. So, this is Automobile Tire Manufacturers Association. If your ladyship would come to page 531.
This is also a natural justice.
It follows the principle, and I had made the submission that this is a classic case. I was for the wrong side, which lost the case. Gullapalli was followed. I had made the submission that the rules expressly state in the anti-dumping context that a hearing will be held after which the parties are to reduce to writing the submissions that they had made. That is, post-hearing written submissions will be given. This is all under the rules because it flows from the WTO agreement. And only those written submissions will be considered, and nothing said during the hearing will be taken into account if it is not contained in the written submissions. I therefore had argued that this is a classic case where it is really the written submissions that ought to be taken into account, and accordingly the personal hearing given by the designated authority for anti-dumping at that time, that was his name at that time, it's been changed a little
It
now.
means a mere formality.
Yes,
This is what you argue.
yes. So, this is what I'd argued, and the court rejected that submission, saying that we want some measure of judicial hearing to be given. Please see at page 569. Para 83. The procedure prescribed in the 1995 rules imposes a duty on the DA to afford to all the parties who have filed objections and adduced evidence a personal hearing before taking a final decision in the matter. Even written arguments are no substitute for an oral hearing. A personal hearing enables the authority concerned to watch the demeanor of the witnesses, etc., and also clear up his doubts during the course of the arguments. Moreover, it was also observed in Gullapalli, if one person hears and the other decides, then personal hearing becomes an empty formality. In the present case, admittedly, the entire material had been collected by the predecessor of the DA. Of course, the DA changed in the middle, just like Ganesh Bharati gave way to this new Joint Secretary Vidyavati. He had allowed the interested parties and or their representatives to present the relevant information before him in terms of Rule 6.6. But the final findings in the form of an order were recorded by the successor DA, who had no occasion to hear the appellant's hearing. In our opinion, the final order passed by the new DA offends the basic principle of natural justice. Thus, the impure notification having been issued on the basis of final findings of the DA fail to follow the principle of natural justice cannot be sustained. It is quashed accordingly. So, this, Your Ladyship, is the outcome. Not that the court will substitute its view based on the material concern. They held it has to be quashed. That is what was held in Gullapalli as well. And in this case, my lords, this is not even the proper procedure to be followed, I submit, as per the rules
The
of business.
procedure as per the rules is, you have raised section 5.
I want to show Rule 4.
What is the corresponding rule?
Yes, Rule 4 of the Environment Protection Rules, 1986.
Sunday.
One aspect my learned friend Mr. Inab Lord wants me to point out to your ladyship, even in Gullapalli, your ladyship may recall, there was a specific rule which allowed the hearing by secretary and minister to pass the orders. But even then, they held that it has to be quashed and set aside. Now, there's an OM in our case, Your Ladyship, which in my respectful submission suffers from two infirmities. First, it doesn't apply to a section 5 here. I'll show Your Ladyship because that's their second difference. There's an OM which, according to them, allows it, of 2009. I'm respectfully submitting that that OM does not apply to a section 5 direction which is governed by Rule 4. And second, and even more importantly, even if there is such an OM, it cannot be enforced, is my respectful submission, because this is now, principles of natural justice are now part of Article 14, as Dr. Singhi had pointed out earlier today. Any direction, please see directions under 4, and I am submitting that this contemplates audi alteram partem in its highest form. Any direction issued under section 5 shall be in writing. 2. The direction shall specify the nature of action to be taken and the time within which it shall be complied with. 3A. The person or authority, officer or authority to whom any direction is to be issued shall be served with a copy of the proposed direction, shall be given an opportunity of not less than 15 days from the date of service of a notice to file with an officer designated in this behalf the objections of any to the proposed direction. Please see that the very first sub-rule makes it clear it is under section 5. 3B, where the proposed direction is for the stoppage or regulation of electricity or water or any other service affected by the carrying on of any industry, operational process, and is sought to be issued to an officer or an authority. Copy of the proposed direction shall also be issued to the occupier of the industry or operational process, as the case may be, and objections of any filed by the occupier with an officer designated in this behalf shall be dealt with in accordance with the procedures under sub-rules 3A and 4 of this rule, provided that no opportunity of being heard shall be given to the occupier if he had already been heard earlier. So, contemplation of personal hearing. And the proposed direction referred to in sub-rule 3B above for this, it should be 3B above for the stoppage or regulation of water or electricity was the resultant decision of the central government after such earlier hearing. Here also, therefore, it is central government which is contemplated, just like in Gulapani. 4. The central government shall, within a period of 45 days from the date of receipt of the objections vary, or from the date up to which an opportunity is given to the person, officer, or authority to file objections, whichever is earlier, after considering the objections of any received from the person, officer, or authority, sought to be directed, and for reasons to be recorded in writing, confirm, modify, or decide not to issue the proposed direction. And 5 does not apply to me. It says where there is a likelihood of grave injury, it is not expedient to provide an opportunity to file objections. It may, for reasons to be recorded in writing, issue directions without providing such an opportunity. So that has no application. So it is in essence 4.1 to 4.4. Hearing is therefore mandated by the statute. Your Ladyship is aware, of course, of the Constitution Bench judgment in Baburam Upadhyay from 1961, which said that the rules shall be treated as part of the statute for all purposes, unless it is
There is no
subject.
doubt that hearing is a part of the statute, and it's a right also, and they have also taken steps to hear you. It's not a case that they have not taken steps to hear you, but your contention is this hearing has been a mere formality, and the person who at best can be said to have heard the matter has actually not passed the order. The notice has also not been recorded by him. So your contentions, your placements, whatever you wanted to say, has taken a backseat.
Yes.
This is what your case is. So at best, if any order is...
May I make one more submission?
Yes.
I am saying that once the statute provides for it, then it's a nullity. That is, this is not a case where natural justice is being read in. This is a case where the statute mandated natural justice and it was not granted to me. If that is the case, then I respectfully submit it is void and a nullity.
Then under such circumstances, if a show cause is issued and you are to be heard and you have not been heard, then if that order is set at naught, but still they will have to hear you. You cannot just say that no further proceeding.
No, I'm not saying that.
That
I'm
cannot
not saying
happen.
that. I'm not
That
saying
cannot
that.
happen.
Yes.
So, as suggested by Dr. Singhi and as per your argument, if you succeed on this point, then you should be happy.
Yes. We are
That's
only
it.
asking for a remand.
That's it.
Remand.
So far as this order is concerned.
That's
Rest of the orders we are not concerned.
right. They will go automatically because
We do not know what will happen.
no. Let me just explain.
I'm concerned only with this order, which is impugned before this.
Yes, may I then make the next step, Your Ladyship? There is a second writ petition where we have challenged the refusal to grant or continue the CTO.
We'll see that later.
Yes,
First, let me ask them as to what do they have to say to this aspect.
Very
You
well.
see, if at
yes.
the
May I
threshold,
just show one more judgment? We've given a copy to Your Ladyship of a judgment which is Nawab Khan, Abbas Khan versus State of Gujarat. Your Ladyship has it?
yes,
Please turn to paragraph 14.
yes,
Where hearing is obligated by a statute which affects the fundamental right of a citizen, the duty to give the hearing sounds in my apologies.
yes, yes.
Para 14. Where hearing is obligated by a statute which affects the fundamental right of a citizen, the duty to give the hearing sounds in constitutional requirement, and failure to comply with such a duty is fatal. Maybe that in ordinary legislation or at common law, a tribunal having jurisdiction and failing to hear the parties may commit an illegality which may render the proceedings voidable when a direct attack is made thereon by way of appeal, revision, or review. But nullity is the consequence of unconstitutionality, and so without going into the larger issue and its plural divisions, we may roundly conclude that the order of an administrative authority charged with the duty of complying with natural justice in the exercise of power before restricting the fundamental right of a citizen is void and ab initio of no legal efficacy. The duty to hear manacles his jurisdictional exercise, and any act is in its inception void except when performed in accordance with the conditions laid down in regard to hearing. Maybe this is a radical approach, but the alternative is a travesty of constitutional guarantees which leads to the conclusion of post-legitimated disobedience of initially unconstitutional orders. And this is the short point that we're making, Your Ladyship. And this we are saying is because of Rule 4.
So whatever was the reason for grant of interim order, that suffices.
Yes, absolutely right.
Your argument is that interim order was given on a particular premise, recording certain facts, taking note of certain facts, but that particular observation has not been met by the respondents, and therefore that interim order should take the shape of a final order.
Yes, Your Ladyship, that's a solution.
Who is there?
And I'm prepared to answer the merits
We'll see
as
that.
well.
You see,
Yes.
the question of merits would come only when they cross this.
Yes, yes.
After
No,
it's a matter of
the only reason I'm going into the merits, Your Ladyship, is to show Your Ladyship that there is no answer to the submissions that we had made in the order
we will not,
at
we will
all.
not go into.
Yes, that's all.
At best, you can say that you have been prejudiced by
Yes,
non-consideration of many aspects of the matter.
yes.
That is a
That's
situation.
right, that's right, Your Ladyship.
And let's call upon them. Will you answer? The order is passed by the.
By the Union of India. It is settled principle otherwise, that the person who hears has to,
The law is quite well settled on that.
there is no notification, quarrel on the facts, not
Yes, you
admitted.
respond. On the natural justice, you respond. You have left the court in between and you have not heard what arguments are.
I can understand your the counter affidavit has been filed, so far as that point is concerned.
Let me just crystallize it. Their whole case is that after the show cause was issued way back in 2020.
2012.
Ultimately, by the order of this court, the same was required to be taken to a logical end. And ultimately, they passed an order.
Yes, my lord, so far as
They
during
made
that.
an allegation that you have not heard them, rather in the sense that the person, what's his name?
Gyanesh
Gyanesh Bhatt.
Gyanesh Bhatt.
He was almost on the verge of transfer orders.
No, he was transferred and after 10th, my lord, 10th of September 2018, my lord, after hearing on 12th, he gave in charge.
Just a minute. Your counter affidavit reveals that hearing was done on 9th, perhaps?
10th, my lord.
On 10th.
10th.
And it also reveals that he noted down the arguments, note sheet, and then the order was communicated on 20th.
Not so.
They have shown the note sheet. Note sheet has been written by some scientist. And the note sheet is dated 10th, 9th.
11th, the note
11th, that's
11th,
it.
note
11th,
11th.
11th note, and then
Date is appearing of 11th.
and then Gyanesh Bharti left on 12th. Now, this noting has not been done by Gyanesh Bharti firstly. It is not even countersigned by Gyanesh Bharti. And thereafter the order was passed. Who passed that order?
But not so far as
What
that.
is the date of the order? Maybe communication is 20th. What is the date of that order?
But the note sheet is there itself, Can you see page 190?
Which is the signal? Because your counter affidavit does not reflect that. That after the noting he passed the order and then he left. No,
No.
that is not your counter affidavit. You have been given this book.
Yes, madam. It is.
You come to page 194.
Paragraph 10, my lord, just kindly for a moment, my lord, the affidavit which has been filed by the union, my lord. It is submitted that the
Page number?
Page number 192, my lord.
One. Yes.
It is submitted that the answering respondent had heard the petitioner along with the other concerned authorities of the state and considered their submissions before taking the decision. This may be seen from the letter dated 29/2018 as well. It is further submitted that the order revoking the environmental clearance is a speaking order wherein the reason for such revocation has been duly recorded. Then we are para 11. It is submitted that the petitioner is fabricating facts and misleading the honorable court by false allegation on the answering respondent. It is settled law that litigant who attempts to approach the honorable court with tainted hands is not entitled to any relief, interim or final. It is further submitted that the submission of the petitioner was duly considered by the respondent, answering respondent, and the submissions relevant to the key issues were also recorded in the order dated 29/2018. It is submitted that the personal hearing was conducted, here onwards. Personal hearing was conducted by the Joint Secretary after approval of Additional Secretary in accordance with the prevailing guidelines. This may be seen from the noting of the file which is annexed here as Annexure R1/2. Moreover, as per the office order dated 39/2009, hearing of the project proponent may be conducted by advisor IA or additional secretary in charge IA division. It is further submitted that the joint secretary is equivalent in rank to the advisor and is a competent authority to conduct personal hearing. A copy of this office order dated 39/2009 is annexed herein as Annexure R1/3. The office order dated 39/2009 had the approval of Honorable Minister of the State in charge for Environment and Forest. It is submitted that all the ingredients of the principle of national justice have been duly complied with while passing the order dated 29/2018, which was stated all the regions. It is submitted that the Joint Secretary Sri Gyanesh Bharti was relieved from his official duty on 12/9/2018. He had heard the petitioner and recorded his observation with respect to the personal hearing conducted on 10/9/2018 at 10 a.m. Before leaving his office. It is further submitted that Mr. V. Vidyarthi joined the office of the answering respondent as Joint Secretary on 12/9/2018. It is pertinent to mention herein that it is well settled principle that the Joint Secretary was working in his official capacity and had duly recorded his observation on the file, and his leaving the office cannot be a substantive ground for revocation of the order dated 29/2018 since the order was issued after obtaining the prior approval of the Honorable Minister in compliance with the law in vogue. This can be seen from the file noting which is annexed as R1/4. A copy of the office order dated 12/9/2018 issued in this respect are annexed as R1/5. It is well settled principle of law that the burden of performing the ancillary job need not be soldiered by the primary delegate, and it is not necessary that the primary delegate himself should perform the ministerial acts as well.
This view was also affirmed by the Honorable Supreme Court in the case of Siddharth Saraogi versus Board of Trustees for the Port of Kolkata, specially petition number so and so, the relevant portion of the judgment in para 4 and 6. So long as the essential function of the decision making is performed by the delegate, or the burden of performing the ancillary and clerical task need not be soldiered by the primary delegate. It is not necessary that the primary delegate himself should perform the ministerial acts as well, in furtherance of the implementation of the decision already taken by the primary delegate. As per the delegation, ministerial or clerical tasks may be performed by the authorized officers. The complexity of the modern day administration and the expansion of functions of the state to the economic and social sphere have made it necessary that the legislature gives wide powers to various authorities when the situation requires it. Today, government functions are a lot of more complex and need for delegation of powers has become more compelling. It cannot be expected that the head of the administrative body perform each and every task himself. Practical necessities or exigency of administration require that the decision-making authority who has been conferred with the statutory power be able to delegate tasks when the situation so requires. Thus, the maxim delegatus non-protest delegate gives way in the performance of administrative or ministerial tasks by subordinate authorities in furtherance of the exercise of the delegated power by an authority. It is denied that the petitioner was unaware of the document. Lordship, can you see, my lord, so
Just
far?
come to page number 53.
Page
50. The running page 242.
242.
The document starts from page number 229. It starts from page number 229.
220, my lord, is annexure 1 by 2.
229 it starts. Subject revocation order.
Yes, annexure R1 by 4.
Yes. You just see it's full discussion of every aspect of it.
Lordship.
Now you come to page 53. Page 240.
Yes, my lord. It has been signed by Sundar Ram.
Not only signed, the entire thing has been prepared by him. He has signed it, submitted for kind perusal, consideration and further on this piece.
Lordship.
This happened on 11/9/2019. What happened thereafter? Where is the role of Mr. Ganesh? Where is his role thereafter? Because he is the person who heard it. The counter affidavit says that he prepared the note, which is not correct. The note was prepared by this scientist. He was present at the time of hearing. Nor it is mentioned that he prepared the note at the instructions of Ganesh Bharti. Nor does it say that Ganesh Bharti dictated him something or gave him certain direction. Howsoever the voluminous order may be, you just think of a situation. Can we as a judge delegate it to somebody? It may be running. It may be running into thousands of pages.
My lord, that is the reason, my lord. Can you see, my lord, so far as the 2009 notification?
The consequences are very serious.
My lord, page 225, my lord.
All the more the serious are the
Yes, my lord, absolutely,
consequences,
your lordship.
all the more responsibility you have.
Yes.
If you file
Lord,
such
can
an
you see,
affidavit,
Lord?
if you file such an affidavit that it is a ministerial function, writing of this note is a ministerial function.
My lord, can you see page
How can
225?
you say this particular? It is as good as a judgment.
My lord, this
It
is
is
noting which has been made, my lord, so far as that part is concerned. It cannot be said to be a judgment, my lord. That is a noting.
You just have a look at it.
Yes, my lord, so far as the finding fact which is there, my lord, this is
See,
on record.
When you say that the person who heard had made notings, where is his notings? It's not there. We can't shut our eyes to this.
My lord, so far as that part is concerned, that part is concerned,
Then
so
it
far
has
as
to, the
Ganesh.
order has to go. The order has to go if you accept that. We'll ask you for fresh hearing. We can fix a date also. But this cannot sustain, and your counter affidavit, I just don't agree to that.
That,
Your officer, secretary level cannot say. It's a ministerial function. How could you make such a statement in a counter affidavit?
that is one of the reason for page 225. Kindly see for a
Let us
moment.
pronounce on that.
Lord, kindly see
When
for a
it
moment.
comes to
Well, they
an
have.
action which is so serious in nature.
Well, that is there, my lord, so far as your lordship is absolutely right, my lord. I am not denying so far as that part is concerned. But my lordship, kindly see, my lord, 2009 policy, my lord. The later office order which was issued in 2000.
I can appreciate that anybody can hear it. But the person who is hearing it, where is his note?
That is not in record.
There?
That is not.
It's not there.
That has not been mentioned, in fact, so far as that part is concerned.
It is something like, Mr. Ganesh Bharti was hearing with a team, and one of the team members
Has taken note of
has
it.
taken note of whatever he has written. And
If at all that was there, my lord, that could have been mentioned herein.
yes, that under
That
his
could have been
instructions,
mentioned under these circumstances, it has been done so.
done, or maybe that he has asked you to
Yes,
take
ma'am,
down the
to take
note
down,
or whatever.
to take down or anything
not
which
there.
has been done.
It's not there. There are many nuances to the, once you grant the clearance, you see their contention is also that at the time of final approval of the environmental clearance, they knew where is the location of the unit. It was very much known to the authorities. Now after that, they issued you a notice in 2012. They also accused me of that because of me this kind of situation has come, because I have taken note of the fact that there was a show cause notice of the year 2012. It was just lying in bedded
No, that is
condition.
that is another
So let
issue.
it
my lord.
remain bedded.
That is another issue, my lord. That is with respect to the merit of the case. That is with
This is
respect to
only
the
because
merit
of
of the
me
case.
this kind of order.
No,
This
your
is what they
lordship.
have argued.
No, your
This
lordship.
order is a fallout of my order.
No. Yes, definitely, my lord. Your lordship has observed with respect to that part, my lord.
It just can't. It just can't sustain. You pass a fresh order, do whatever you want, but it just can't sustain. So you tell me a date. Ask your secretary. Whenever he is available, whatever be his convenient date, I'll put a date and time. They will go here and we pass it.
Lord, I will communicate after lunch, my lord.
You communicate after. I think that should suffice your purpose.
I will
Your
communicate.
ladyship, there's just one additional thing, your ladyship. I wanted to show your ladyship only the order of her ladyship versus managing. Your ladyship may recall that the interim order was carried out. I was just requesting that your ladyship may.
You see, I will not go into that.
No, just observe,
Yes.
just observe para 87.
That was relating to further clearances, assuming that there were violations. Of
Yes,
it.
yes.
That is a separate thing.
No, may I then request one thing? Your ladyship may only reproduce what is at para 3 of the order, which talks of the implications for the unit. I just wanted to update the data. We have 8,000 people, my lords, working directly for us. 2,000 people working directly for us, 8,000 people contractually employed, and a further 20,000 who derive indirect employment. Example, truck drivers,
It's a
canteen
running
services.
unit, full-fledged running steel
Yes.
unit. What else is required?
No, I just wanted to mention these facts because they should keep it in mind. 2,000 directly employed, 8,000 contractual workers, 20,000 indirectly employed, 8,000 crores worth of steel at that time in 2019-20 it was 4,200. 8,000 crores of steel for the nation is being produced here, and we are paying 2,200 crores in direct taxes, indirect taxes to the exchequer, that is GST, etc. This is independent of the 8,000 crores. Just to reflect these facts in your leadership's order, so that they keep this in mind when they're giving us the hearing.
Howsoever high your turnover may be,
I bow down. The environment has to be kept in mind.
environment has to be kept in mind, and I'm sure that they will take care of that. You can just, if you want to put it in your submission, it's okay. But the matter can be just kept short on this aspect of it.
Very well.
That will be sufficient.
Very
Just
well.
give me a
But
date
I'll
and time.
give
And
you-
one more thing, I
And
have a
but-
feeling that their social responsibilities have not been taken care of.
Your Lordship may observe me also.
I can't observe my feeling. Okay, I cannot observe my feeling.
Then
But,
definitely I'll
but
communicate.
you see, not even one
I'll-
school you have opened.
I'll
till
communicate,
class
my Lord,
12.
but they themselves
I'll tell
can
you
give
one
an
thing.
undertaking to that.
Our state
They are
is
doing all these things.
starved of quality education. Our state is starved of quality education. We have not many schools, but quality education is still not coming
My
up.
Lord, in India, my Lord,
One
yesterday,
school, at least
yesterday,
till
my Lord,
12, it should be
a
there.
girl student, my Lord,
Yes, she topped.
she topped in 10th examination from Jamshedpur.
She is from Jamshedpur, no?
Yes,
You
ma'am.
just see her background also.
Yes, my Lord.
That also makes a difference.
That is there, my Lord, but at least, my Lord, now Jharkhand
Bokaro
is at the
also has
top.
very good school.
Jharkhand is
But
at the top, my Lord, that
Oh,
is
yes.
there itself.
Topper in what? UPSC.
No, no.
No. 10th
10th
examination.
final exam.
Yes, all India.
ICSE. ICSE.
ICSE, all
Your
India.
ladyship, if we are left to function, I'm sure I can persuade them to open one top quality school up to 12th standard.
This will not only cater to your employees,
To
it
everybody.
will cater to everybody.
That's true.
And I'm sure you will be in a position to get good teachers. Actually, you see, teachers from other places are not coming over here. And when we meet the teachers, they are not even able to speak. English teacher is not able to write a paragraph. Am I correct, Mr. Rajiv Ranjan? Am I correct? When I see their petitions, I ask them, which subject are you teaching?
Your ladyship, from the limited amount I've been in Jharkhand,
No,
I have the
because-
highest respect for the quality minutes of the lawyer, your ladyship, of the lawyers, the people
Lawyers
who I
They
met.
have also done our schooling from what's here in Jharkhand.
Yes, we have also
Yes,
done
so
our
I
schooling,
have
yeah.
the
That
highest
too from government
respect
school.
for them. But your ladyship is right.
And this is an obligation under your environmental clearance itself.
Yes.
That you
CSR
have to
fund.
take, CSR is different. This is an obligation under the clearance.
Yes.
You cannot use CSR fund for this. CSR is different.
Yes. Your
Right.
ladyship is right.
This environmental clearance has a condition
Yes.
that you will take care of their health and you will take care of education and other social responsibilities.
In fact, your ladyship, one just needs to reflect on what happened in Jamshedpur. The way Tatas have become the Maibap of the entire area, and one realizes that it is possible for a company to be simultaneously thinking
I must share one thing with you. We are from Jharkhand. People would not leave Tata from Jamshedpur even if they have lucrative offers, because the kind of social security they provide in terms of the basic facilities, electricity, road, security, and hospitals, and also education to next generation, employment to one person of the family. It's huge.
That's right.
Nobody wants to leave.
Ideally, one
They
should
do
be
not
like
give
that.
much salary in terms of money. But this is what they give is quite a lot.
Ideally, every company should be like this. Your ladyship. This is my view.
And I was thinking one day that there should be a policy that any male or any person for that matter who is having 100% attendance, a portion of the salary should go to the spouse. Isn't it?
My friend says that they have that in Goa. He comes from
You
Goa.
have this in Goa? It goes to the spouse?
Yes, the spouse automatically becomes owner of 50% of the estate of the husband.
That is inheritance.
So everything.
Everything.
In fact, your ladyship, most of us, just under the influence of the spouse, automatically fall into that bag.
We don't have any option. All the things are in
ATM
their
is
custody.
being
itself.
operated by them.
We used to beg from them itself.
Okay, that should be sufficient.
Yes.
Your ladyship, would your ladyship consider asking them to issue us a fresh show cause notice?
No, we'll ask you to appear right from here.
Okay, a fresh notice of hearing at least.
No, we'll fix a date right from here.
Very
They will
well.
just inform us a date, we'll fix a date right from here.
Very
Date,
well.
time, everything.
Very
Lord,
good.
I'll just, Lord,
You just tell me two things. And what is the date on which they can appear as per your convenience, and how much time will it take to complete the procedure? These two things. Will you let me know?
Your Ladyship, may I also make one more request? And this is a very serious request. As I said, as I said, Your Ladyship, the High Court, any observation by the High Court has enormous effects on the government officers. Would Your Ladyship say only this, because we have submissions on the merits which have not been taken into account in our respectful submission in the order. Would Your Ladyship only says that it should be the objections filed by us and our submissions at the hearing should be considered with an open mind.
I will just make an observation that you will go for oral hearing, and post oral hearing you can also file your written submissions, and all the matters should be taken care of. That much should be sufficient.
Maybe considered with an open mind, if Your Ladyship can say.
It has to be open-minded.
No, the difficulty is the moment it comes from the High Court, they think that it is an implicit, implied
direction to reject.
This is
No,
this is the way that they think.
If they think, they should resign.
No, but this is the way they think.
Not
Your
fit
Ladyship.
to hold the
So I'm
post.
only requesting Your Ladyship, in whatever way Your Ladyship considers fit, to just observe this much.
Decide afresh.
They will decide afresh.
Fresh means a fresh
Yes,
decision has to be
without being influenced by the previous order.
Certainly.
That Your Ladyship
That
thinks.
has to be there.
Yes.
Without being prejudiced by the previous.
Yes.
Your
That-
every aspect of the matter can be taken care
Yes.
of. And as of now, you are aware of what are the contours, what are the niceties. You have already seen one of the impugned orders, so you know that what can come. So you can address on that.
We will
And
do
you can
that.
also give a fresh written submissions.
Yes, we'll do that.
That would be better, so that every aspect of the matter is taken care of.
Yes. And Your Ladyship may give us a little time so that we can prepare everything in advance. The date of hearing can be kept after 2 months or 3 months.
2 months? You are operating without
July second week.
without a clearance.
No, we have a clearance.
You have a clearance.
And we have stipulations that we are complying with. So, if it can be in July, we'd be grateful
That
because
will
all
be
the
too long.
council.
No, we can't give such.
July, because now it is
No, they will give a date and you just.
May
provide.
1st, Your Ladyship. So, if
Let
they
me just find out what date.
Very
Right.
good. Most grateful to Your
So
Ladyship.
this record will go with that.
Yes.
And what about the other one?
The other writ petition, Your Ladyship, is
Has become
against,
interpreters.
in a sense, because the entire order is based on the revocation of the EC.
That's right. So that goes automatically.
That's right. That's right.
You are there for that.
all subsequent actions not pursuant to this order, particularly
Yes. So all the actions of the other respondents will be subject to the result.
They will be kept in abeyance or whatever.
It will be subject to the result of
Yes,
this.
result.
Because your clearances on pollution was also
Based upon-
awaiting
yes.
this particular order. And the rest of the compliances, regular compliances, they will have to do as per the.
So daily procedure.
I think fine. Just take time. Let me just start.
You are most grateful.
If I miss anywhere, you just let me know. I will record his appearance also online.
Yes, please record Dr. Sindhi's appearance. Your
उनका
Ladyship.
appearance, आप अपना एक appearance दीजिए सबका जो नहीं है उनका मत दीजिए. Those who are not there, don't give them. Was there means what? Was hardly there. Ask him to be here for a minute.
Yes, please.
Quickly heard the learned counsels for the parties. ये WPC number 4850 of 2018. This petition has been filed for the following reason. The learned senior counsel for the petitioner has submitted that the case can be disposed of on short point of gross violation of principles of natural justice by passing the impugned order contained in letter dated 29/2018 in bracket Connection 19. The learned counsel has submitted that the unit involved in the present case is an integrated steel plant set up in the district of Bhopal, and all necessary clearances, including environmental clearance, within bracket EC, was accorded to the petitioner by letter number J-11/2007/157/2006-IA.11/1 dated 21/2008. And the environmental clearance has been revoked by impugned order contained in letter dated 29/2018. The learned counsel has referred to Section 5 of Environment Protection Act 1986 and Rule 4 of Environment Protection Rules 1986. To submit that the revocation of environmental clearance is governed by the aforesaid provision of the Act and the rules, and prior to revocation there is a mandate of granting an opportunity of hearing. The learned counsel has submitted that the show cause for revocation was issued way back in the year 2012, which culminated in the impugned order dated 29/2018. He has submitted that the hearing in connection with revocation of environmental clearance was granted by
Bharti. BHAR.
I lost that page.
194. Sorry. 242.
Was granted by Joint Secretary Shri Gyanesh Bharti. Where is that hearing Proceeding?
The minutes are at page 242, I believe.
Yes.
246. 246.
And as referred to the minutes of hearing held on 10/9/2018 and has submitted that during the course of hearing, Shri Gyanesh Bharti, the Joint Secretary, was accompanied by a number of officers, including one Shri Sundar Ramathan, Scientist D. The Learned Council has also submitted that Shri Gyanesh Bharti was scheduled to be transferred and transfer order was already issued. And ultimately he gave the charge on 12th. He submits that
Afternoon of 12th.
afternoon
not
of
even
12th.
whole of 12th.
Afternoon of 12 September 2018. The Learned Council further submits that a plea was raised in the writ petition that the Learned Council further submits that as per the counter affidavit filed by the Union of India, it has been asserted that Joint Secretary Shri Gyanesh Bharti had heard the matter and he was relieved from his official duty on 12/9/2018 and he had recorded his observation with respect to personal hearing conducted on 10/9/2018 at 10 a.m. before leaving his office. He was succeeded by MS Vidyavati, who joined the office as Joint Secretary on 12/9/2018 itself. The Learned Council has submitted that, along with the counter affidavit, the note sheet has also been placed on record. And as per the note sheet, the entire proceeding, the notice has been prepared and signed by Sundar Ramanathan, Scientist D, on 11/9/2018, who was present during the course of hearing. And therefore, the statement made in the counter affidavit that the noting was prepared by Shri Gyanesh Bharti does not appear to be correct. The Learned Council has also submitted that even if the noting was prepared by the Learned Council has also submitted that the noting having been prepared by another person other than Gyanesh Bharti, who was to hear and pass an order. The EU order passed dated 20th of September 2018 has been passed in gross violation of principles of natural justice and cannot be sustained in the eyes of law. The Learned Council has submitted that revocation of environmental clearance has serious impact on a running industry, and many aspects of the matter which were raised by the petitioner during the course of arguments and the materials placed before the authority have not been taken care of while passing the issued order of revocation. We have submitted that apparently the matter was, he has submitted that not only the natural justice has been violated, but the petitioner has been highly prejudiced by the impugned order, and therefore the impugned order be satisfied. The learned counsel has relied upon the judgment passed by Honorable Supreme Court, reported in AIR 1959, bracket close, SC 308, Gullapalli Nageshwar Rao versus APSRTC, and has referred to paragraph 15, 17 and 35.
And 32.
32 and 35. And has submitted that the personal hearing is not a mere formality, and the authority who has heard the matter has to pass appropriate order. In the present case, the notings was also done by by the other person and not by the authority who heard the matter. The learned counsel has also relied upon the judgment passed by Honorable Supreme Court, reported in bracket 2011, bracket close to SCC 258, paragraph 83 and 84, to submit that the aforesaid judgment passed in the case of Gullapalli Nageshwar Rao Sutra has been followed. These two judgments are sufficient?
I think so. And Jharkhand, your leadership may cite only two for the proposition that it is void.
The learned counsel has also relied upon the judgment passed by Honorable Supreme Court, reported in bracket 1974, bracket close to SCC 121, para 14, to submit that where a hearing is obliged by a statute which affects fundamental rights of citizens, natural justice having not been satisfied, the order itself is void ab initio and a nullity in the eyes of law. The learned counsel, paying the learned ASTI, has submitted that, has referred to the counter affidavit. missing out on the page number. Actually, I'm not noted. Counter affidavit. And has in particular referred to paragraph 10 and 11. And has submitted that the revocation of environmental clearance is a speaking order wherein the reasons has been duly recorded and has further stated that as per the counter affidavit, the personal hearing was conducted by Gyanesh Bharti, the Joint Secretary, and he exercised such power after approval of the Additional Secretary in accordance with the prevailing guideline. And has further submitted that though Gyanesh Bharti was relieved from duty on 12/9/2018, but he had recorded his observation with respect to the personal hearing conducted on 10/9/2018, and consequently the ingredients of natural justice has been duly complied. He has further submitted that the Joint Secretary was working in his official capacity and having recorded his observations on the file before leaving the office, the same cannot be a substantive ground for revocation of the order dated 29/2018, since the order was obtained after prior approval of the Honorable Minister in compliance with law. However, during the course of hearing, when the learned ASGI was confronted with the proceedings as annexed in the counter affidavit, he could not deny that the proceeding, the notings, the file notings has been recorded under the signature of Surendra Ramanathan, Scientist D, on 11/9/2018. Who also indicated that it was proposed that the revocation order who submitted that decision on the matter is taken by 18/9/2018 so as to facilitate the filing of affidavit in the High Court by 20/9/2018. The course of action was also suggested, and one of the course of action was revocation of environment. The Learned Council has further submitted that at best the matter may require fresh hearing, and for that a date may be fixed by this court itself. After hearing the learned counsel's appearing on behalf of the plaintiff, so far as learned advocate Deputy State of Jharkhand is concerned, to submit that the order regarding revocation of environmental clearance having been passed by the authority under the union, he has nothing to say in the matter. That should be sufficient from your end.
It's not my order, but I cannot say anything.
That's right. After hearing the learned counsel's appearing on behalf of the parties, this court finds that it is not in dispute that after completing the necessary formalities, the petitioner had set up the integrated steel plant and the environmental clearance was also granted by order dated 12/1/2008. However, certain violations were noted with respect to location and other related issues, and consequently show cause notice was issued to the petitioner seeking to revoke the environmental clearance. This happened as on, when was the shoe cause issued?
31/8/2018.
No, first
6/6/2012.
it is all fallout of that.
Yes.
6/6/2012. The matter remained pending, and ultimately the there is that order by which they were directed to decide. There is one order.
And I'm happy to be there at the beginning and now at the end, Manas. I'm sorry, Manas.
I am giving dictation slowly so that I do not commit any.
I appreciate it. I appreciate it.
And as it is, I become conscious when you are here.
No, Manas. Could not come the part so I came immediately after that for a short while.
The matter is over?
No, it's going to go on, but there's lunch here now. So Lordship will dictate. I just didn't want to disturb.
Yeah. Where is that order? An order was passed by this court on 25/8/2018. Perhaps this is the order, page number 135, wherein the petitioner was directed to approach the Union of India with their proposal/application for regularization of alleged violation without prejudice to their right, title, interest, possession and nature of the property an advance submission before the authority pursuant to the show cause notice issued to them dated 6/6/2012, 138.
Your Ladyship, we just found the order. It's 16/7/2018. It is there in the other writ petition, Your Ladyship. That is in WP 1873.
You will find an order in 135 also, page 135.
Just look at the
As an issue 15.
we have enclosed it as
Page
action.
number 138. It's there.
Filed in 2018 as well as.
It's there, I think.
It appears to be the other writ petition, Your Ladyship. That is in WPC number 1873 of.
Let's not refer to that order. That will be sufficient. Ultimately, the impugned order has been passed, which is under challenge in this proceedings. Impugned order is page number?
It's
Page 167?
169.
160. It is dated 20th of September 2018. The grievance of the petitioner in short is the violation of natural justice in passing of the impugned order. The counter affidavit of the state of the Union of India, paragraph 10 and 11, and further materials placed on record reveal that though the matter was heard by Gyanesh Bharti, the Joint Secretary, on 10/9/2018, but the notings were prepared by Sundar Ramanathan, Scientist D, on 11/9/2018. And also signed by Sundar Ramanathan. But admittedly, the notings were not prepared by the Joint Secretary. And immediately thereafter, on 12/9/2018, he was transferred. And after his order of transfer, the impugned order was passed. This court finds that though the hearing was done by Shri Gyanesh Bharti Joint Secretary, but he neither prepared the note nor passed the final order to be placed before the concerned minister for approval. And consequently, the whole purpose of hearing stood frustrated. This court is of the considered view that the matter regarding revocation of environmental clearance being a serious matter and many aspects of the matter are involved. The records does not reveal that the Joint Secretary who heard the matter had the occasion to apply his mind inasmuch as even the note was not prepared by him or under his signature. This has certainly caused great prejudice to the petitioner, and consequently the reviewed order cannot be sustained in the eyes of law on account of violation of principles of justice. Then we will quote these judges, these paragraphs. I quote. As a result of the aforesaid discussions, the impugned order cannot be sustained in the eyes of law, and the same is accordingly set aside. However, the matter is certainly required to be heard afresh by the Joint Secretary only. Who will hear it? Same person? By the present incumbent, the Joint Secretary.
may say by the appropriate authority.
फिर आप लोग appropriate authority में you have lot many issues. You have lot many issues on appropriate.
No, because your ladyship will never pass an order saying it's a joint secretary, and your ladyship may recall in that order.
Since this order is being set aside only on this ground, so it should go to the Joint Secretary.
No difficulty. We
To
have
the
no difficulties.
concerned Joint Secretary, for which the petitioner is, you are also to be heard. Are you also to be heard? Are you sure?
They were heard.
You were heard. You were heard.
No, they were heard at the
Yes,
present
page
order
number
last.
231.
All right, on the better we will also pay.
Comments and views of JSPCB,
Pollution board.
Pollution Board.
Pollution. All right.
Who were the persons who were appearing? Pollution
If
Board
your
and
ladyship sees page 246, the people who were present were the JSPCB member secretary, the IFS officer, DFO, who is under the state, as well as the additional collector of Bokaro district.
So what's the state?
At page 246.
State of Jharkhand as well as not the pollution board.
and also the authorities of the concerned authorities of the state of Jharkhand and the Pollution Board. Which date you have not come up with the date?
Your ladyship, may I suggest only this. Your ladyship may say, may hear and dispose of it expeditiously, uninfluenced by the previous order.
No, I just. Okay, they will give a date at
Your ladyship may give a date, no difficulty.
11 o'clock, right? 11 a.m. Upon their appearance, the Joint Secretary shall hear the matter and pass fresh order within a period of 1 month from the
Your
date of
ladyship,
the
I would request, last time, I'm hoping to be able to persuade your ladyship on this. Let me just notice one thing in the order. It is stated, that is the revocation order, before that it says, in view of the High Court's guillotine, that is on 20th.
That I will give that right.
No, I'm saying because of
1
that,
month.
because of that, we are going to pass this order immediately.
We will not keep it open.
And there's one more aspect, your ladyship. I'm only submitting this. Your ladyship wants that they should decide. We can't object to it in fact or in law. We can't object to that. But your ladyship may just keep this in mind. Since that date, in 2018, when your ladyship passed the order, as your ladyship pointed out, much water has flowed under the bridge. We have now given 913 acres of non-forest land to be reforested. We have paid huge amounts of money. Now, if they want to consider that proposal,
We will not say anything more.
your ladyship would then be tying their hands. After
I
all,
am not tying their hands.
after all,
I am concerned with the impugned order, and that is it.
no, I'm only saying this. Your ladyship may say expeditiously so that they can take their time. But
We can't keep it open.
no, I'm only submitting this. Last
We can
time
increase the time to 6 weeks or whatever.
they
But
should not hurry and do something like last time, Manoj.
If anybody needs any extension of time, they will file an application. What's the big deal about it? If you need any extension of time, you file an application. Don't act in a hurry.
There's one more.
You see, you conduct the hearing on 10th and say that on 12th you have to file an affidavit in support. This you should not be doing. You take your own time. You tell me how much time.
Whenever it would be required, we will file.
If you need any extension, there is no problem. We will not keep it open.
Your ladyship, there are court holidays in Jharkhand.
You are not going to appear, please don't.
No, the last time Indrajit Sinha appeared.
Not appear. What happens if a contrary order is
He
passed?
can appear.
Also coming to
No, my friend Indrajit Sinha.
Because he knows the records best.
Balance?
Because he knows the records best.
No, and Mr. Lad, both of them appeared and the order was passed. Now, I'm only submitting one thing. I have no doubt, given the importance of the matter and it's a running industry of the size that your ladyship knows, they would want counsel to be present. Right now, the Jharkhand High Court holidays are around the corner, Supreme Court holidays are around the corner. So, all that I'm submitting is, your ladyship may give a reasonable time, here and decide within, for example, a period of 3 months would be appropriate. And that is not a very long
Okay, I'll
time.
make it 3 months.
Very well. And your ladyship may observe that if they want more time, they can come and
I don't need to observe. 3 months is more than sufficient.
Very well, your ladyship. Then now in the second matter we
Okay,
have.
it's for 3 months. Just please hold on. You have to catch it light. Not 50. Just hold on. Just hold on. It is further observed that it will certainly be open to the petitioner to file the written submissions before the authority, so that
After the hearing.
after the hearing, so that no point raised during the course of hearing remain untouched while passing the fresh one.
And your ladyship would observe, I'm sorry, I've been a bit busy trying to keep up with what your ladyship is saying. Has your ladyship observed that they shall pass an order uninfluenced by the previous order?
I have not yet done so.
Very good.
It is made clear that this order has been passed only
on account of violation of principles of natural justice, and this court has not gone into the merit or otherwise of the action taken by the respondents. It is sufficient, it is further observed that it will be open to the concerned authority to pass appropriate order in accordance with
Uninfluenced by the previous order.
which previous order. There is no previous order.
That's one that's being set.
Yes, since the interim order has been set aside, therefore the order has to be passed without being influenced by the interim order.
Great.
That is sufficient.
For this matter, this is sufficient.
What about the next?
The next matter, I made a mistake. I must apologize to your leadership. It is completely related, but it was filed before the final order was passed. And if your ladyship sees your ladyship's order in the second writ petition on 16/7/2018, there's an orders compilation which we had handed over in 1873. If your ladyship just sees the order of 16th of July 2018, page 3 of that order,
Just
16/7/2018. In 1873.
This case has become infructuous.
Your ladyship, there's one small problem which I should have told your ladyship earlier. This was filed while the show cause notice was pending,
That's right.
and they refused to renew my CTO.
That's right.
Your ladyship, because of that, your ladyship had passed this order, considering the submissions made by the council for the parties, 16/7/2018, your ladyship. Maybe just,
That is an interim order that we
yes, an
passed.
interim order.
Yes. 16/7/2018. I have it here.
Yes, the last paragraph of 16/7/2018.
Yes.
It says on page 3.
Just a moment. Sixteen, 17.
Yes,
Page
page 3. Considering the submissions made by the counsel for the parties, this court grants interim order that to the extent that till the next day the petitioner be allowed to operate under the supervisory regulatory control of the respondent board, who may carry out periodical checks as to the adherence by the petitioner to the aforesaid pollution control acts. And in the order dated 25/8/18, your ladyship has made the observation in paragraph 10, 25/8/18. So far as interim relief is concerned, this court finds that the order passed by the respondent Jharkhand State Pollution Control Board dated 23/8/18 appears to be directly dependent on the final decision which is yet to be taken by the Ministry of Environment, Forest and Climate Change on the show cause issued to the petitioner as far back as in the year 2012. So this is the reason why your ladyship passed the interim order, and then thereafter your ladyship will see the last 4 lines of the same para. Accordingly, the operation, implementation and execution of the order dated 23/8/18 passed by Jharkhand State Pollution Control Board is hereby stayed till 27/9/2018, and the interim order dated 16/7/2018 is hereby extended till 27/9/2018. And in the previous sentence, your ladyship has pointed out, as per the submission made by counsel appearing on behalf of Union of India, is shortly going to take a final decision in the matter after hearing the petitioner. So the same situation is there today. So your ladyship may give us the kindly consider granting us the interim order of 16/7/18 which was till the next date, petitioner be allowed to operate under the supervisory regulatory control of the responding board, substituting for the next date till the decision is taken by the MOEF.
WPC 1873 of 2018. The learned counsel for the parties have submitted that in view of the order passed in 4850 of 2018, the petitioner is relegated to the status that the show cause notice issued way back in the year 2012 is yet to be taken to a logical end by passing a fresh order. It has been submitted that the Pollution Control Board had refused to grant the clearance on the account of pendency of the show cause issued by MOEF. The learned counsel has submitted that till MOEF passes a final order, the unit may be permitted to operate in the same condition with the same rider as was placed by passing order dated 16/7/2018 in WPC 1873 of 2018. The learned counsel has submitted that as per the interim order, the petitioner was allowed to operate under the supervisory regulatory control of the respondent pollution board, who was to carry periodical checks as to the adherence by the petitioner to the pollution control acts, subject to which was awaiting the final decision. The learned counsel submits that the petitioner is ready to adhere to all the pollution control norms and in order to operate the similar observation may be made by this board, which may continue to be operative till the MOEF passes a threshold. Any objection? The control board?
They have to adhere to not to the
Yes.
regulatory notice.
The learned counsel, the learned advocate general and the counsel here for pollution board. Nobody appears for pollution board.
I think the advocate general can
Representing the authorities of the state has no objection to the aforesaid extension of to the aforesaid relief, subject to the same condition as was imposed by this court. In view of the aforesaid facts and circumstances, this petition being WPC number 1873 of 2018 is also disposed of with an observation that the petitioner would continue to run the unit till the Joint Secretary passes a final order, subject to the condition that the petitioner would operate under the supervisory regulatory control of the respondent Jharkhand State Pollution Board, who may carry out periodical checks as to the adherence by the petitioner to the pollution control laws.
But the petitioner will run the industry subject to the final decision taken by the
Certainly, subject
or also said till they take the decision. Or they take a
is
decision.
subject to final decision. Till subject to final decision.
Here they succeed.
Yes. The aforesaid order would continue to operate
only till the final decision of the joint secretary.
Your Ladyship, we again say till but subject to.
Subject to the decision.
Because if
Yes.
we succeed,
Till and
succeed.
subject to the decision. Certainly subject.
Till bonus will be last हो जाएगा.
ठीक है, subject to the decision.
Whatever may be the order, not that will follow.
Yes.
would your Ladyship consider, and if entirely to your Ladyship, would your Ladyship consider saying that if the order is adverse, they will get a period of 2 weeks?
I will not say.
Very well, Your Ladyship.
The order we communicated, I think they communicate through mail only, always
By post, I believe.
by post. The parties to furnish their email ID before the authority for all communications regarding date of hearing as well as also passing of the final. Yes, yes.
I'm most grateful to you.
I don't know, at last these cases are over.
We are aware
I
that it was
think
weighing on your
you have
lordships.
to, you see, it's some policy decision is required to be taken as to how this unit is going to operate. So I
Absolutely.
think the parties will have to use their good offices. We really can't help it.
We realize that this has been weighing on your Ladyship's conscience. And we are
Unnecessary
very,
it is pending.
yes, we're very grateful to your Ladyship for the consideration. Most grateful.
All IAs closed.
Yes.
All IAs closed and rest is over. They will give us the date for your appearance. बहुत लंबा date मत दे दीजिएगा. Yes, council. Give a proper date and time. It will take 2 days for uploading.
Most grateful.
It will have corrections also, so please bear with me.
Most grateful.
Your Lordship is giving some dates. Some date Your Lordship is giving?
No, date for appearance. I will take 2 days time to upload the order.
Yes.
And it will have some corrections also. So
Very well.
please bear with me. The operative portions will not change, but I'll add a few.
Very deeply obliged. Very deeply obliged.
Most of them.
Grateful.
Date by